So, counsel, ready?
Yes.
Yes?
Yeah. Hope so. Very trusting. Another one. Hang on, I can't.
You're exciting talking, but you don't try to
Nice if you can hear some citrus 35 minutes as well.
That's the point of Winston Library.
Certainly can.
There's a case for that.
There is.
Your Honor, today we have a hearing in the matter of CFI number 014-2016. The first claimant is Mr. Rafed Khorafi. The second defendant is Mrs. Amra Ali Abdul Latif Al-Hamad. The third defendant.
Yes, good morning, Mr.
Yeah.
President.
Good morning.
The third claimant is Mrs. Alia Muhammad Sulaiman Rafai versus first defendant, Bank Sarasin Alban Middle East Limited. Second defendant, Bank J Safra Sarasin, formerly Bank Sarasin Alfo. The claimant is represented by Orlando region, QC assisted by Alistair Thompson, Roger Bowden, Basma Al-Hawari, and Hamdan Al-Shamsi of Al-Shamsi Law Firm. The second defendant is represented by Ewan Makweta, QC, and Camilla Benjamin, QC, assisted by James Abbott and Ritwig Josh of Clifford Chance Law Firm.
Good morning.
Right.
Now, in terms of timings, my friend and I broadly agreed to keep to a time frame as follows, that I will continue to a little after 11 a.m. today. My friend will then have until lunch and approximately 2 hours after lunch, but leaving a proper time for reply, bearing in mind your Lordship's constraints today.
Right, thank you.
My Lord, I was just going to finish off on the impecuniosity argument. And there's one point I haven't dealt with on that, which is the rather weak suggestion in the claimant's skeleton, paragraph 71, where it said it would be incorrect to assume that the second and third claimant's resources would be available to the first claimant. It won't escape your Lordship's attention that the three claimants have together been making common cause in litigation against these defendants for nearly a decade now. Even though Mr. Bowden, in his third witness statement, paragraph 11, has confirmed that the second and third claimants are not now making any claims against my clients in this action, they wish to remain parties, he says, because they still may make a claim against the first defendant. And of course, the skeleton for this application and the representation today is for all three claimants. Now, the second claimant is, the wealthy second claimant, as we saw, is the first claimant's mother, and her assets were, of course, heavily relied on, as your Lordship saw, by the claimants in seeking to resist the stay of Deputy Chief Justice Chadwick's order for payment. And the first claimant, my Lord, does not even assert in his evidence for this application that the second claimant, his mother's assets or liquidity, would not be available to him. He doesn't even say that. The fact, it's as asserted in my friend's skeleton, that the second claimant it said in her evidence in the 2009 proceedings that she makes her own decisions about her money, does not, of course, mean that that money will not be available, or would not have been available to support the additional claims. And of course, she, as was in the evidence in the first proceedings, she'd given a power of attorney to her son in respect of the banking relationship with the second defendant, as did the first claimant's wife, the third claimant. So we're talking here, my Lord, about funding, also, we are talking about funding the extra legal costs of new claims back in 2011 and 2012, when all three claimants were vigorously pursuing the 2009 proceedings together. They all pursued all claims. And the idea, frankly, that if the first claimant wished to make further claims in that action, that the second claimant would not as necessary have supported him is in our submission quite fanciful. And the position we have today, is a little bit reminiscent of the debate that one sometimes has on security for costs applications, where the claimant says, if you order security, it'll stifle the claim. And the court in those situations is, of course, able to look at what sources of funds would be available or likely to be available to the claimant to meet orders for security and so forth. And in those circumstances, as your Lordship knows, which are somewhat analogous, the burden is very firmly on the claimant to show that there's no prospect of funds being available or forthcoming from any other source or other party whose interests may be affected. My Lord, that's all I wanted to say on impecuniosity. I was going to move now to the question of the wholesale breach of the Aldi guidelines in this case. And that may be an appropriate moment just to recap on the law generally in this area. I showed your Lordship yesterday the well-known passage in Johnson and Gore Wood, which is in your Lordship's authorities bundle, our authorities bundle, behind tab 11. And it's the passage on bundle page 134, from which one gave a number of propositions that I went to yesterday. But in the main highlighted text of your Lordship's copy, you will get below the policy statement at letter B on the page, you get Lord Bingham telling us that, of course, it can be an abuse if the court is satisfied that a claim should have been raised in earlier proceedings, if at all, that it's not necessary for there to be an additional factor like a collateral attack, although that will be obviously more abusive. He makes the point that could does not necessarily mean should, and he says it's, of course, a broad merits-based judgment. And in addition, he says in a passage that we looked at yesterday that it will rarely be an abuse unless there is an oppression or unfair harassment of the defendant. Now, my Lord, there's an attempt to criticise us, to criticise paragraph 17 of our skeleton for raising as a headline question the issue of whether the claims now advanced were part of the subject matter of the earlier proceedings. Well, my Lord, that is, of course, a very relevant and legitimate question, and a central question to two issues, both the issue of whether the current claims could have been made in the earlier proceedings, but also, importantly, whether they should have been made in the earlier proceedings, because if they were already part, and the subject matter was already part of that action, then that points very strongly, it's a very strong indication that the claims should have been made in that action. Now, my Lord, it's common ground that the Henderson abuse doctrine is part of the law of the DISC. We've referred in our skeleton to the paragraph 14 to the TMV case and the Theron case.
What was your reference there?
Paragraph 14 of our skeleton, my Lord. We refer to those two cases. I can take it. I wasn't going to take your answer.
Yeah, sorry, I just didn't think. Yeah,
yes, it's, these are where the court has recognised Henderson as part of the law. The TMV decision was a decision in May of 2014, but in our submission, it was never in any serious doubt that DISC law would apply Henderson, and the claimants have been advised throughout by an experienced legal team, and they must be taken to have known that. And as your Lordship knows, the RDC is modelled closely on the CPR. In fact, I was informed today, and your Lordship will know better than I, that this court actually used the CPR between 2005 and 2008 until the RDC was in force. And in procedural matters, the DIFC closely follows the CPR. And if your Lordship has that authorities bundle, and just these provisions are at tab 32. You'll see some extracts from the rules. And at rule RDC 1.6, you will see page 557, you will see that these rules, foot of the page highlighted, have the overriding objective of enabling the courts to deal with cases justly, dealing with a case justly, insofar as practicable, and then over the page at sub 5, allotting to it an appropriate share of the court's resources while taking into account the need to allot resources to other cases. So the DIFC has aligned itself with English principles of case management and the overriding objective, which includes, of course, dealing with cases justly, allotting appropriate court resources, and taking account of the need to allot resources to other cases. And if your Lordship just looks over the page at 559, at Rule 2.10, and particularly 2.10.3, starting at the top of 210, if no provision is made and no appropriate form is provided by the rules, or any law enforced in the DIFC, the following rules of practice and procedure shall be followed and adopted. And your Lordship will see at 3, insofar as the guide does not deal with the matter and makes reference to the CPR together with any prescribed forms with such changes as the court considers appropriate to be applied in the circumstances. So if there's no provision in the rules or guide, the court shall adopt the CPR with such changes as it considers appropriate. And then finally, when you look at the strikeout provision on page 560 over the page, which is Rule 4.16, it says the court may strike out a statement of case if it appears to the court, and then 2, that the statement of case is an abuse of the court's process or is otherwise likely to obstruct or just disposal of the proceedings. Insofar as the rules don't spell out the ALDI guidelines, the court can, of course, refer to the CPR commentary, which, for your Lordship's note, is in that authorities bundle that's tab 35. Now, it's said that ALDI and the ALDI guidelines should be given less weight here, although the claimant skeleton is 39, I think, maybe 31, I'll have that checked, accepts the relevance of the cards on the table approach, it's 39 I'm told, accepts the relevance of the cards on the table approach in ALDI. But it said the less weight in the DIFC because it said it's not embodied in a rule or practice direction or decision of the DIFC. Well, it's not embodied in a rule or a practice direction in England. The ALDI is simply an aspect of the Henderson abuse principle, which has particular emphasis on the efficient use of court resources, avoiding oppression thereby to the parties. Now, just to look at ALDI for a second, my Lord, it's behind tab 13 in the same authorities file. Decision of the Court of Appeal back in November 2007, and the passage now often referred to is at page 206 of the bundle. I hope it will be highlighted in your Lordship's copy.
Yeah.
Where Lord Justice Thomas says this at 29, paragraph 29. I also wish to add a word as the approach that should be adopted if a similar problem arises in the future. In circumstances such as those that arose in this case, the proper course is to raise the issue with the court. ALDI did write to the court, as I've set out, but not in terms that made it clear what the court was being invited to do. WSP and Aspinwall knew of ALDI's position and were before the court on numerous occasions. They did nothing to raise it. Parties are sometimes faced with the issue of wishing to pursue other proceedings while reserving their right in existing proceedings. Often no problem arises. In this case, ALDI, WSP and Aspinwall each in truth knew at one time or another between August 2003 and the settlement that there was a potential problem, but it was never raised with the court. I've already expressed the view that it should have been. The court would at the very least have been able to express its view as to the proper use of its resources and on the efficient and economical conduct of the litigation. It may have seen a way, if a way could have been found to determine the issues applicable to ALDI in a manner proportionate to the size of ALDI's claim, and without the very large expenditure that would have been necessary if ALDI had to participate in the trial of the action. It may be that the court would have said that it was for ALDI to elect whether it wished to pursue its claim in the proceedings, but if it did not, that would be an end of the matter. It might have inquired whether the action against excess underwriters could have been expedited. Whatever might have happened, in this case, is a matter of speculation. However, for the future, if a similar issue arises in complex commercial multi-party litigation, it must be referred to the court seized of the proceedings. It is plainly not only in the interest of the parties, but also in the public interest and the interest of the efficient use of court resources that this is done. There can be no excuse for failure to do so in the future. That's been around since November 2007, and Lord Justice Thomas refers to the proper and efficient use of court resources and economical use of court resources, which of course are principles embodied in the RDC and applied by this court. And ALDI was a case of alleged oppression where the defendant, I'll come back to that point. I won't complicate the current discussion with that. But ALDI's been around since November 2007, my Lord. It's now been applied, including ALDI, in 5 Court of Appeal decisions of the English Court of Appeal. Your Lordship looks at the index to this authorities bundle. Your Lordship will find ALDI is listed at tab 13. The English Court of Appeal has applied ALDI and held it to be mandatory. There are no exceptions in 5 cases. Now, ALDI at 13, Stewart and Goldberg at 14, Gladman at 16, Clutterbuck at 23, and at Creety at 24. All decisions applying ALDI and saying it's mandatory, there's no excuses. It is, and if I could just show you, Lordship, what Lord Justice Briggs said about this in the Gladman decision behind tab 16. And at bundle page 305. Lord Justice Briggs at 64 and 65, as he then was, says this.
By page you want?
On page 305, bundle page 305. Thank you. Internal page 14.
Yeah.
He says this, by contrast, his, referring to Lord Justice Thomas, observations about avoiding these difficulties by a prompt application for proactive case management were directed mainly at the future rather than the past. He plainly regarded the requirement to refer a contemplated future claim for case management directives in the earlier claim as mandatory and as serving the public interest in the efficient use of court resources. He described a failure to do so as inexcusable. Furthermore, in the Stewart case, both Lord Justice Sedley and Sir Anthony Clark, Master of the Rolls, spelt out in express terms that a failure to follow the LD guidelines involved the claimant running a risk that the pursuit of a second claim would constitute an abuse. As has been repeatedly stated, the conduct of civil proceedings is a process in which the stakeholders include not merely the parties, but also other litigants waiting for their cases to be tried, and the public at large, who have an interest in the efficient and economic conduct of litigation. Consider that Mr. Justice Arnold was correct to treat a failure by the appellant to follow guidelines laid down as mandatory future conduct in 2 successive reported decisions in this court as relevant matters, pointing to a conclusion the second claim constituted an abuse of the process of civil litigation. So it's mandatory, it serves the public interest in the efficient use of court resources, and the passage expresses in terms the risk that a claimant runs if you don't comply. In my submission, ALDI should be applied with its full vigour in the DIFC and treated as mandatory in the DIFC as it is plainly in England and has been for quite some time, as would have been known to the claimant's advisors. Now, in response to the obvious non-compliance with ALDI in this case, the claimants say in their skeleton several times, but most obviously at paragraph 86, that even though they failed to raise these claims at the proper time, there's no prejudice to the second defendant, because if they'd raised them, the court would have directed a separate hearing or trial in any event. And they say, that's more or less the position you're in the 2016 proceedings, so no additional burden. Now, when we come to look at the hypothetical CMC, my lord, we'll see that that's not right. But in any event, there are 3 preliminary points I think it's important to make before we do look at what may have happened at a hypothetical CMC. My lord, the first point is that, and this is apparent from Creety and other cases, but perhaps Creety is a convenient place to find it. It's in the authorities bundle, it's tab 24. This is a recent decision of the English Court of Appeal, where Lady Justice Arden, giving the judgment to the court, indicated that it was at paragraphs 50 to 52, page 478 in the bundle. She indicated in this decision that as part of the broad merits-based exercise your lordship's engaged with, the court can look at the seriousness of the claimant's breach of the mandatory guidelines and seek to determine or look at what would have happened if the necessary application had been made. The court, of course, has to bear in mind, as Lady Justice Arden says, the timing of the hypothetical CMC because as she says in paragraph 50, just about 6 lines up from the bottom of paragraph 50, the application should have been brought as soon as reasonably possible after Crete should have appreciated Threadneedle's potential liability. So the application should have been brought as soon as reasonably possible after the claimant should have appreciated the defendant's potential liability. And in Gladman, Lord Justice Briggs refers to the earliest opportunity. Now, New Rochester, so what Lord Justice Thomas said in Albi itself. So that's the first point, is that you're looking at a hypothetical CMC as soon as possible after the first claimant, in this case, should have appreciated the second defendant's potential liability for the current claims. That is to say, potential liability for these heads of loss on the one hand, and potential deceit claim on the other hand. Now, the second preliminary point, my lord, is that the hypothetical CMC inquiry is one part of the broad merits-based assessment. It's not simply a question of saying, well, if the first court would have ordered a separate trial, there's no prejudice and therefore no abuse. That is not the case. One has to remember in particular that Crete and some of these other cases deal with subsequent cases against a different defendant. Because if you are not sued before, if the defendant has not been sued before, it's much easier for a claimant to say, well, on the Aldi hypothetical CMC, there's no prejudice to this defendant. This defendant's not already faced a decade of litigation. The position in my submission is materially different where you are suing the same defendant for a second time. And if your lordship would look in the authorities bundle back to tab 12, to the Dexter decision in the English Court of Appeal, where Lord Justice Clark reminds us of this very point at bundle page 186. At 49, he's summarising the principles from Johnson and Gore Wood, and he says at 49.2, a later action against B is much more likely to be held to be an abusive process than a later action against C. So later action against the same defendant is much more likely to be held to be an abuse than a later action against a different defendant. And your lordship, there's good reason for that, my lord, because your lordship recalls the policy, as stated by Lord Bingham, behind this very law: finality of litigation, don't vex the same defendant twice in the same matter, and economic use of the court resources, and so forth. And when you are suing the same defendant again, you are contravening all of those policy considerations, including abusing court resources. And in our submission in this case, that amounts to oppression and unfair harassment. The third preliminary point, my lord, is that another vice you potentially get, particularly where you allow the same defendant to be sued again over the same facts, and there's been no Aldi warning that there's another claim in the pipeline, is that you allow the claimant a potentially huge tactical advantage. My lord, and this goes to the seriousness of the Aldi breach, the breach of the Aldi guidelines. And what I mean by that is this, is that the claimant gets a dry run, gets to test the waters, cross-examination of the claimants and defendants' witnesses, and seeing how the submissions and evidence go down and are received by the court. And if he gets the factual findings that he wants, he gets them in circumstances in which the defendant has prepared for the case, thinking it's been sued for all relevant losses, thinking the important issues are A and B, and this is a claim for 75 million. And in fact, it turns out later that the more important issues were C and D, and this is a claim for $1 billion. And what's more, as the claimant says here, you're actually bound by issue estoppels from the first action. Even though I got those issue estoppels without telling you, in breach of mandatory court guidelines, without telling you that this was that a billion claim was going to be brought on the basis of these very matters. Now, in the current case, my lord, the claimant is claiming extensive issue estoppels from the first action. If your lordship were to take up their particulars of claim in the new proceedings, which is number 1, tab 5, your lordship can put the authorities, actually I will need the authorities again if your lordship can keep them close. But I want to go to the particular statement in the new action, bundle 1, tab 5. And it starts at paragraph 51 of the pleading, which is on bundle page 32. But 51 says in the liability judgment, that's Deputy Chief Justice Chadwick's liability judgment, the court made a number of factual findings which provide part of the factual background. Those findings are res judicata and thus binding to the parties of these proceedings and are referred to as appropriate below. And then between paragraphs 51 to 75, you get a whole series of matters where there are references to the liability judgment, which are said to be res judicata and issue estoppels, including the statement itself at paragraph 66. That's the deceitful statement itself at 66, and so on, in a load of other matters. And we now know that issue estoppels.
Sorry, you lost me.
Paragraph
66.
66,
Oh, 66.
66 and page 36 is where the statement is said to be res judicata, and including, and we know from the RFI that I showed you logic yesterday, they're going to also say that attribution of vicarious liability effectively is also res judicata. And that carries on to around about paragraph 74 to 75. These purported issue estoppels, my lord, in my submission, have been obtained in a very oppressive and unfair way, a troubling way, and as a consequence of, and they were obtained in that way as a consequence of the claimant's inexcusable breach of the Aldi guidelines, because they never told us these claims were coming. And they never told us that actually there's a huge significance to this conversation in August 07 that those representing the defence at the time would never have appreciated, because no claim was based on that at the time. And
are you saying you would have called some different witnesses, or produced some different documents? Or
well, my lord, we'll have to review all that. Of course,
no, but can you identify something now?
Well, my lord, there would certainly have been a much more extensive cross-examination of the first claimant, had that been the case. Because if I could just develop that, my lord, if this matter were to proceed, we are likely to be saying that we are not bound by at least some of these issues.
There's your argument that it isn't res judicata, which seems to be a different point. I'm just asking a question. Assume you're right that they contend it's res judicata and legitimately so, and you say that they gained that apparent advantage unfairly. I'm just trying to work out what it is that would have happened if your clients had realised the point was more important than they thought it was at the time.
Well, it's difficult to say exactly what would have happened, but if I can give your lordship an example. In this case, you recall that Deputy Chief Justice Chadwick's judgment, which I showed your lordship yesterday, said that the claimant's first claimant's evidence about that statement was not challenged.
So you have to.
It's back on bundle 8 to tab 75. And this was at page 3955. And it's he makes the not challenged observation in the end of paragraphs 210 and 211, referring to the evidence of Mr. Khorafi and the evidence of his office manager, Mr. Noor, Lord Justice Chadwick. Now, we also have in the bundles the transcript of Mr. Brindle's cross-examination, and which is over 5 relatively short transcript pages, where a case is put that there was a collateral shortfall, but the first claimant was made aware of, but the detail of that case is not put, and it's a small, modest part of Mr. Brindle's cross-examination, understandably, and obviously what didn't register with Deputy Chief Justice Chadwick as being a serious challenge, because he says what he says in paragraphs 210 211. He said it wasn't challenged. And one is left with a distinct impression that if the defendant's counsel had been aware that $1 billion potentially hinged on that statement.
It doesn't matter whether it's $1 billion or one, does it? I'm not quite sure I follow the significance.
Well, the significance is you can be sure that the cross-examination of the first claimant and the cross-examination of Mr. Noor on that statement and that exchange would have been of a wholly different order and depth if the defendants had appreciated that potentially $1 billion turned on it. I mean, there's nothing, my Lord, would focus the mind quite like realising that this is the key point in the case, and this is the key point at which you could have a ruinous judgment against you. And it would not have been 5 short pages on a peripheral issue. It would have been a deep and extensive cross-examination of a different order. My Lord, the statement, the August 07 statement, is not even on the list of issues of the previous action, or the case memorandum of the previous action. Those are in the bundles at 3 tab 48. I'm not going to go there because it's just to prove a negative, but they're not there. So, of course, when Mr. Brindle was cross-examining, he had absolutely no, or Mr. Black, they had absolutely no idea that that the statement was to have this future significance. And my Lord, that's why, if this action proceeds, we're likely to be saying, not bound by at least some of these issues, particularly related to the statement itself. First of all, because, in fact, as your Lordship knows, issue of estoppels only apply to matters necessary for the court's decision, and the findings in relation to the statement are not necessary for the court's decision. I mean, we've got Spencer Barrow, if your Lordship needs to see it, but I'm sure your Lordship's aware of the general law on that the issue of estoppel applies to essential steps in the court's reasoning, rather than matters that were not essential. But secondly and importantly, the way in which these estoppels were obtained in breach of the ALDI guidelines, keeping back a much bigger claim up your sleeve, is in itself abusive, and fairness would demand that we be entitled, should we so wish, to relitigate those issues. All of which means that in the 2016 proceedings, if they proceed, one may end up having to recall witnesses and go through at least some of the same depressing story in this part of the case all over again. And that is not something to be lightly brushed aside, because as I'll show you, Your Lordship, the courts have been troubled by this type of abuse before. And whether the first claimant did this consciously for his own tactical advantage or not, and if it was conscious, it's obviously a worse abuse. But either way, the effect has been to give him a potentially huge litigation advantage in this new claim for a rather eye-watering sum. I said that judges have expressed themselves troubled by this kind of abuse. Authorities bundle tab 14, we see Stewart and Goldberg. We also can put the other bundles away for the moment. Stewart and Goldberg was, this is Court of Appeal applying Aldi. I mean, this was a case where there was a breach, there was a claim for a breach of solicitor's undertaking, and late in the day the claimant got information about a misrepresentation and an inducement to breach contract case, and no steps were taken to include those. And by the skin of their teeth, the claimants survived an abuse finding for a number of reasons. One was the knowledge came late, it was incomplete in relation to the misrepresentation claim, and because the relatively simple solicitor's undertaking claim was quite advanced, there would have been considerable delay in those proceedings. Of course, because solicitor's undertakings are supposed to be relatively simple to enforce and not complex. Far cry from this case, where we have a multi-million-dollar, very complex litigation ongoing. But Sir Anthony Clark, Master of Rules, says a number of things that are currently pertinent in his judgment at bundle page 235, paragraph 92. He says this: in the instant case, although the claimant knew that he had a potential claim for inducement to breach the contract after he received Mr. Lynn's witness statement in October, he did not make that clear either to Mr. Lynn or to the court. In my opinion, he should have done so, and it's at least arguable that his deliberate failure not to do so for partisan tactical reasons renders the second action an abuse of the process of the court. And then over the page at 96, he says this: for my part, I do not think the parties should keep future claims secret merely because a second claim might involve other issues. The proper course is for parties to put their cards on the table so that no one else is taken by surprise, and the appropriate course in case management terms can be considered by the judge. In particular, parties should not keep quiet in the hope of improving their position in respect of a claim arising out of similar facts or evidence in the future, nor should they do so simply because a second claim may involve other complex issues. On the contrary, they should come clean so that the court can decide whether one or more trials is required and when. The time for such a decision to be taken is before there is a trial of any of the issues. In this way, the underlying approach of the civil procedure rules, namely that of cooperation between the parties, robust case management, and disposing of cases including particular issues justly, can be forwarded and not frustrated. While these considerations have been highlighted in Aldi, they've been relevant considerations at least since the CPR came into force in 1999. It's for these reasons that, in my view, the claimant should have notified the first defendant and the court of a proposed inducement claim in the autumn of 2000. And then dropping down to the last 5 lines, for the reasons I've given, the reasonable course is to raise the matter with the first defendants and the judge, rather than to make a tactical decision to keep his powder dry until we saw how the cross-examination of Mr. Lind went. And in Clutterbuck, my lord, behind tab 23, also English Court of Appeal, Clutterbuck was a case, my lord, where wrongdoing was alleged in relation to 3 joint venture agreements, and in the first action, the claimant sued on 2 of the joint venture agreements against one co-venturer, and in the second action, the claimant sued on all 3 against a different co-venturer. And the claim on the first 2 joint venture agreements held to be an abuse. The claim on the third was not, but the court was troubled by the fact that the claimant had a dry run at some cross-examination in the first action about the third joint venture agreement. And one sees that from bundle page 468. And this is the judgment of Lord Justice Kitchen, where at 104, paragraph 104, he says this, that what then of the other matters to which the deputy judge had regard? I'm conscious that Mr. McCormick, Mr. Gonzalez, and Mr. Pickstock were cross-examined in the Alamudi proceedings about the Cleveland Place project. I'm also conscious that Mr. McCormick was cross-examined by reference to a file of documents of which he had little or no notice, and that Mr. Cakebread, counsel of the claimant, sought to suggest to him that Mr. Nichol had been dishonest in his dealings with regard to Cleveland Place. I also accept that Mr. Gonzalez's professional integrity and competence were vigorously questioned. It was these, amongst other matters, which led the deputy judge to observe that it was hard to resist the conclusion that claimants had used the Alamudi litigation as an opportunity to conduct trial 1 of their claims against Mr. Nichol. I have to say that I have found this a troubling aspect of this part of the appeal. As the deputy judge observed, the Court of Appeal in Stewart and Goldberg deprecated this type of behaviour, On the other hand, Mr. Justice Aspwin has made no findings in relation to the Cleveland claim, so there's no risk of inconsistent conclusions. Further, the Deputy Judge accepted the treatment of the three witnesses was a long way from the treatment of one of the key witnesses, Mr. Bishop, in the Gladwin case. So obviously, to some extent, fact-sensitive, but there is a theme here that the Court of Appeal is rightly troubled by the idea that you get a dry run at these matters at the evidence one time, and if it goes your way, you then mount a further claim on the back of the fruits of your first litigation. My Lord, that brings me to the hypothetical case management conference in this case. As your Lordship knows, in respect to the real estate losses, they should have been raised and could have been raised and should have been raised in the middle of 2012, we say at the latest. Probably before, because they knew all about them before and they could have claimed them and didn't require the deceit claim in order to claim them. The deceit allegation, and they could have complained on the fraud basis because fraudulent misrep was already claimed in the first action. And then the deceit claim, it should have been raised at the latest, we say, after disclosure, which was August 2012, which was finished, completed in August 2012. It was actually, the case that the first defendant was going to put was actually clear from the first defendant's defense back at the end of 2010, as I showed you, Lordship. But certainly there can be absolutely no excuse for not raising the deceit issue. If it was pleadable now, it was pleadable at least by August 2012. And even if the deceit claim were raised later than that, for example, following witness statements in early April, 4th of April 2013, it should have been accommodated with relative ease into the action because the statement was already part of the subject matter of the original action. It wasn't as though it was introducing an entirely new factual investigation. It may have upped the parties' enthusiasm and resources that they threw at investigating that claim, but I'm quite sure your Lordship would have felt if he was hearing a CMC in April 2013 that it could be accommodated. So it's extremely unlikely in my submission that had Aldi been followed, the court would have said, no, pursue these claims in a separate action. That's extremely unlikely, my Lord. The court would then have used its considerable and flexible case management powers to determine how best to deal with these new claims that were being raised. And there are, of course, a number of possibilities. It's possible that the judge would have given directions for it all to be tried together. If that had delayed the trial, then that would have been the claimant's own fault in our submission for not raising them early enough. But as Aldi observed, or Justice Thomas, the judge might have put the claimants to their election to say you either bring these claims now or you shut up for good. But that would have been available to the judge, as Lord Justice Thomas said. The court might have divided the issues up and decided to split the trial at that point in some way. If it did, I would suggest the most likely course that the court would have taken is to have trial one to deal with issues of liability, attribution, which were common to all the claims, causation, which we will see overlaps considerably, and negligence duties of scope of duty and remoteness and so forth. And if trial two had been necessary, that would be quantification of losses. But certainly all within the 2009 proceedings. What actually happened in this case, as Your Lordship may or may not recall, was that there was no split trial ordered. The parties were supposed to be ready for everything for the trial in May of 2013. And what in fact happens, if Your Lordship wants to see this from Deputy Chief Justice Chadwick's judgment, one can get it from his judgment at Bundle 10.
Can I just get the timetable again?
Yes, of course.
One thing I was trying to find in the chronology. When did disclosure or discovery take place?
It was between June and August 2012. Your Lordship gets that from Mr. Abbott's witness statement. which
well, it may be, I'm looking at the time.
yes, yeah, it may not be in the agreed chronology.
It's not there, okay.
If it's not there.
Although there's a discussion about specific disclosure in January 2013, it seems a little surprising. Okay.
Yeah, that's a bit surprising to me. I might have to get to the bottom of that.
Well, I'd like some help with that. Okay.
The disclosure.
Anyway, and the actual CMC took place in April 2012, correct?
I think that's right. That's the date given in the agreed chronology.
And who was the judge at the CMC?
I would expect it was Deputy Justice Chadwick. I think that's what.
I don't think you should assume that.
Well,
I don't know.
I don't know. No,
Well,
I'm checking.
somebody must know.
I'm checking.
Where's the order that was the result of the CMC?
It may not be in the bundle,
Right.
but we can
Okay,
chase
well,
that
I'd like to see
down.
that.
We'll chase that down.
Thank you.
So this is the CMC order, and the reference for your lordship for
Anyway, you wanted to go to his judgment.
well, own judgment, just to show your lordship what happened.
Sorry, yeah.
Which is it's one of the later judgments. If your lordship takes up bundle 10, tab 100, your lordship will see that a later judgment of Lord the Deputy Justice Chadwick. This is his quantum judgment in 2015. It's just to show your lordship what had in fact happened in the case, so that your lordship knows. I was just going to go to a short passage at 4831.
Thank you. Yeah.
At sub 4 in the middle of that page, he's just reciting some of the history. And at 4 he says, although this was not a case in which there had been an order for a split trial, the trial in May 2013 proceeded on the understanding common to all parties that, and the court, that the claimants would not adduce evidence of quantum at that stage. It had been anticipated there was a real possibility the forensic accountants whom they respectively instructed would be able, given time, to reach agreement on the figures. My Lord, I'm just trying to explain what happened actually. We're trying to consider a counterfactual of the hypothetical CMC. What actually happened was that everyone was supposed to be ready for a quantum at the first action, and that because there was optimism that there might be agreement, there was an understanding that they wouldn't call quantum evidence, and in the hope that there would be agreement. And in the end, of course, items were not agreed, and there was an attempt later on after liability judgment to adduce further heads of damage, and that was all resolved in later decisions. Now, but reverting to the hypothetical CMC model, sensible case management on our hypothetical model would have, you would have had, in my submission, liability, causation, attribution, scope of duty and remoteness issues tried together in the 2009 proceedings, same witnesses, same legal teams, same judge, same experts in some cases, because, for example, there were Swiss law experts on the question of attribution under Swiss law, liability of my clients, which overlap distinctly with the current proceedings. And, of course, because of the findings he made, Deputy Chief Justice Chadwick never had to make a finding of whether we would have been liable for a fraudulent misrepresentation under Swiss law. And all of that evidence will have to be got up again and brought forward and cross-examined on again. These issues, my Lord, all belong together in the 2009 proceedings, and there would have been huge cost savings and economies if they had been tried together in terms of the time and cost to the parties and the duplicated costs that would now by contrast have to come in the new action.
And I've got the dates and the judge for the CMCs that exists in your lordship now. There was a CMC on the 6th of January 2013, Mr. Justice Chadwick. A CMC on the 3rd of April 2013, Mr. Justice Chadwick.
Okay, well, perhaps somebody could revise the timetable.
We'll do that, my Lord. We'll try and find the orders made on those occasions as well.
Thank you.
My Lord,
And in May 2012 was also Sir John Chadwick. May 2012 was also Sir John Chadwick, and that set down the trial.
None of those are mentioned in this one. Thank you very much.
The May 2012 date is the 22nd of May.
Well, obviously those preparing the Greek chronology, one has to take a view of what is and isn't relevant. There's a huge amount of history in this case, just to make the point that these issues all belong together, Your Lordship will recall, for example, I've made the point about the attribution issues. There were causation issues in the first trial, which involved, of course, the claimant's wealth and assets. Your Lordship will recall, because these came up in the appeals, issues surrounding the status of the claimants as investors, whether they would have answered in their forms whether they had more than $1 million of liquid assets, and so on. So this is a good question, the suitability of the investments. There were issues, Your Lordship may recall, about what the first claimant did with the $35 million loan he was given by the second defendant, including the cross-examination of the two Bugatti cars he bought, first for $1.2 million. There were causation issues on whether, instead of incurring further losses, this was a mitigation issue too, incurring further losses, the claimant should simply have paid off the ABK lending, and did they have the wherewithal to do that, and so on. And these are all issues canvassed before, in the first instance, before Deputy Chief Justice Chadwick and before Your Lordship in the Court of Appeal. And of course, those overlap. The issue of the wealth and wherewithal of the claimants overlaps with the causation case very strongly here, because the whole causation case in the 2016 action is all about the fact that Mr. Al-Khorafi paying $10 million to the bank, investing $10 million with the bank in August 2007, meant that his whole property empire came crashing down. So his wealth will have to be investigated in detail, and the assets and the business dealings relating to that will have to be investigated in detail in the new action if it proceeds. I think the short point, my Lord, is that there would be very substantial economies in terms of time, convenience, costs, and so on, if this matter had been properly case managed at the proper time. And there are, of course, the underlying policy considerations about not wasting and abusing the court's resources that Your Lordship will be well aware of. Yes, there would have been an increase in costs in the first action, possibly a significant increase, or probably a significant increase in costs in the first action, but it would have been as nothing compared to the situation we now find ourselves in, having to start the whole thing again. We're told we now face a trial of several weeks. Mr. Bowden, third witness statement, paragraph 36. Now, if this action survives the strike count, there will be potentially a forum convenience point to be addressed, which I'll mention in a moment. There will be the contentious question of what issues Stockholms bind and what don't, and whether fairness demands that we should be entitled, if we wish, to relitigate some of those, which may result in some of the same witnesses of fact being recalled. Mr. Al-Khorafi will have to be recalled, obviously, at a minimum, with Mr. Noor and so on. And the new trial, of course, will have to have pleadings, disclosure, witness statements, other interlocutories, potentially appeals, and so on. Experts called all over again, sometimes on the same subject matters like Swiss law. We're threatened with other foreign law experts, because the first claimant says to Mr. Bowden, paragraph 11, that they want to reserve their right to bring claims under Swiss law for breach of contract or breach of regulatory law or statute. So Swiss law experts, interpreters, etc., and no doubt lots of accountancy evidence about the real estate losses. My Lord, I'm going to move to collateral attack, if I may. This is an aggravating feature of the current case. Now, as Lord Bingham said in that passage we looked at, my Lord, this kind of additional element is not necessary, but where it's present, the action will be much more obviously abusive. Your Lordship will recall, as we discussed yesterday, there was a late attempt to introduce some of the tower losses. I say some because they were put at 37 million at that point into the 2009 proceedings. And the possibility was first raised, Your Lordship has bundle 9, and the consequentials hearing after the Deputy Chief Justice had delivered his liability judgment. There was a consequentials hearing on the 27th of October 2014, and at bundle 9 at 77 is the transcript of that, tab 77. And I just want to take you to one passage, page 4098.
Sorry, what divider?
Divider 77.
Yeah.
At page 4098.
Yeah.
And this is Mr. Hill QC at the consequentials hearing for the claimants. And he says in the passage at the foot of the page, as I understand it, my Lord, yes, I do not have the detail of this, so I cannot say too much about it because I personally just do not know the detail, but that, as I understand it, is what has happened. We would like to submit that that is something that could be included. Sorry, I've got the...
So it being what?
Sorry, Marlon, I've got the wrong reference. I was looking for the reference to... Yes, sorry, I need the passage at the top, further up the page. I beg your pardon, Marlon. The passage about just below the first hole punch where Mr. Hill says it's not necessarily a question of what has been paid, it's what loss is sustained. Now, I'm not talking about loss and profit or anything like that, but for example, I can tell my Lord that since the trial, there have been some foreclosures on property as a result of the ABK lending, leading to at least one instance of property sold. And then dropping down to where I was, as I understand it, my Lord, yes, I do not have the detail of this, so I cannot say too much about it because I personally just do not know the detail. But that, as I understand it, is what has happened. We'd like to submit that that is something that could be included. I accept that my own friends might want to argue about that, but I would submit that the time to argue about it is when we put in, we've seen the evidence, as it were. That's not raising a new claim. This is a loss which is an ABK loss, which has happened since the trial, as I understand it. The reference to an ABK loss, my Lord, is that RAFCO, the property company, also was funded by ABK Bank, which also funded some of the purchases of the notes. So there's two types of ABK lending: lending to the property company and lending for purchase of the notes. And as a result of that hearing, the judge's order is at 78, tab 78, where he, and at page 4220,
yeah.
4220. Yes, it's the second page of the order, where this is the first order where the defendants were ordered to pay money, and the damages were to include, if your Lordship looks at 3B2, losses arising out of the claimant's relationship with ABK. That's for the first defendant, and similarly at 5B2 in respect of the second defendant, losses arising out of the relationship. And then at 7, he directs a further hearing for a quantification of these losses. And then at 8, he says the claimant shall file and serve on the defendants any evidence in support of their claims on quantum for the quantum determination ordered under 7 by no later than the time given, subject to further order of the court, for which the claimants may apply in writing with a draft of further evidence on which they seek to rely. Such evidence shall be limited to evidence of events which have occurred since 10th of July 2013, being the last day of the trial in these proceedings. So he directs there be a quantum hearing in relation to these losses in the undetermined losses in paragraphs 3 and 5, and there's a liberty given to reduce further evidence in the terms that I just read, and you now, as your Lordship, his reasoning for that is on page 4225, paragraph 9, where he says that this, paragraph 9, the second matter which requires explanation is the restriction on further evidence I've included under paragraph 8. There is force in the defendant's submission that this is not a case in which the court was asked to order or did order a split trial. The evidence on which the claimants are entitled to rely for the purpose of assessing the quantum of their claims is the evidence that was before the court at the trial, subject to the possibility that the quantification of those claims may be affected by reason of post-trial events. It's for that reason that I think it right to restrict the evidence which the claimants may adduce in support of their contentions in the quantum determination of post-trial matters, but I leave open the possibility there may be some further matters which justice requires the court to consider. And if there is, the claimants may apply in writing to rely on evidence of those matters. Such application to be made in advance in order to determine such application, if any, the court will require to see in draft at least the further evidence that we wish to rely on. So, my Lord, that's, as we saw yesterday, my Lord, as I took your Lordship to the November 2014 volley of evidence that came in, there was an attempt to adduce evidence of the tower losses at that stage in November, and Mr. Justice Chadwick ruled on that attempt at, we have to go to bundle 10, at tab 92. This is the Deputy Chief Justice ruling of the 13th of January, where one sees at paragraphs 23 to 25, page 4741, what he says about that. I'll summarise that. I'm conscious of the time, my Lord, but what he's saying between 23 and 25, because he's already made that order that we looked at, and he says that the question he has to look at, determine at 23, is whether these losses were losses, quote, arising out of the claimant's relationship with ABK, because that's the order he had made, and he decides that they don't, because you don't interpret that as meaning as any wider than the ABK lending to buy the notes. It wasn't intended to refer, and in its context didn't refer, to losses arising from a different relationship with ABK in relation to property lending with Rafed Khorafi. And so he said you can't include this evidence. Now, the claimants sought to appeal that ruling, and they sought permission to appeal in a skeleton behind tab 95, which on bundle page 4763, tab 95.
What divider we were looking at?
We were looking at 92.
92, yes. I'm sorry, I just
No, not at all, my Lord.
Yeah.
And as I mentioned, the claimants sought to appeal that decision, excluding the evidence of the tower losses.
Yeah.
And at the top of the page 4763, in their submissions, they said this at 41. Further, the judge should not in any event have excluded the claimant's claim on this basis, effectively as a strikeout, without going on to address it at the quantum hearing, so as to reach a conclusion on whether there were recoverable losses which had been proved. And their application for permission was heard by Justice Roger Giles, and that is the same bundle at the next tab, 96, where he refused permission. He held at 21 there was no support for a wider meaning in the judge's words, and at 29 there was no procedural unfairness, paragraph 29, page 4775, and paragraph 30 is of some significance. He says this at the through to page 4775. Parties exchanged skeleton arguments prior to the January hearing, and I read them and the transcript of that hearing. It's correct that the defendant's submissions place some emphasis on first claimant's fourth affidavit, the witness statements, going beyond post-trial events. But the defendants put other matters in support of their application, including that it was unpleaded and a new head of loss. In the course of submissions, the judge observed that he had to decide whether the RAC 4 loss, that's Mr. Khorafi's evidence putting forward the Tower claim, was properly to be regarded as a claim which arises out of his relationship with ABK. The answer of counsel for the defence was to the effect that the orders made on 28th of October 2014 did not permit an unpleaded head of loss. So he's noting the objection that was made that this is an unpleaded and new head of loss. Not content with that, the claimants tried again for reconsideration before Justice Sir Richard Field, which is in the next, no, sorry, not it's next, but 2 tabs 99, where he reconsidered the matter. And if I could invite you also to paragraph 34 of his ruling at page 4813, where he rejected the attempt for reconsideration. And at 34, he said this: as to the claimant's remaining submission, that in any event the Deputy Chief Justice should not have excluded rank 4 as he did, effectively as a strikeout, but should have considered whether the RAFCO losses were recoverable at the quantum hearing. In my opinion, there's nothing in this contention. The 28th October order was a matter of necessary, albeit unexceptional, case management, with the object, inter alia, of giving directions for the quantum hearing, both as to issues and admissible evidence. In promulgating those directions, the Deputy Chief Justice proceeded, as he was undoubtedly well entitled to do, by reference to 1, the fact that there had not been a split trial; 2, the recoverable losses as identified in his judgment, which, so far as they arose out of the claimant's relationship with ABK, founded exclusively on losses arising out of the relationship between ABK and the claimants as borrowers from ABK in relation to the funding of their purchase of the Sarasin investments. And in the last reference that I was going to take the logic to here is when the matter came before, later, before the Deputy Chief Justice Chadwick, when he was considering costs of the quantum proceedings. In fact, this is, yes, it's the same bundle at 104, right at the end of this bundle. A separate order, even though the defendants were losing on costs, of course, he made a separate order in respect of the application to admit that new evidence of the Tower losses. And one sees that at page 5086 of the bundle. And he addresses that at paragraph 38. And he says this: the defendants submit correctly that their applications to exclude evidence were successful in relation to the witness statement RAC 4. They also submit again correctly that the effect of excluding that evidence was to strike out a proposed claim on behalf of the claimants in respect of losses estimated at 37 million, said to have arisen in relation to borrowings by RAFCO, a company owned and controlled by the first claimant, from ABK, and said to have been guaranteed by the first claimant. And he goes on at 40 to say the court is persuaded it would be appropriate to make a discrete order in respect of costs. So the defendants got their costs of that episode. The claimants say there's no collateral attack on these decisions in the current proceedings because they say in their skeleton in paragraph 13 it's no part of their case that the Deputy Chief Justice was wrong on it about anything. Now, and I think that's the way it's put, is to say that the losses rulings we looked at were about the interpretation of Lord Justice Chadwick's order. Well, they're about the interpretation of the order and the exclusion of evidence, of course. But that would be, my Lord, a triumph of form over substance, because in form what those decisions we looked at decided is what the Deputy Chief Justice's order meant and what evidence was to be allowed. But in substance, they were deciding, as in my submission to Richard Field's judgment recognises, is that the Tower losses should have been raised before trial in the 2009 proceedings. There had been no split trial, and it was by then too late. And in my submission, it would be manifestly unfair and a collateral attack on the substance of those decisions to allow the current proceedings to be brought now, particularly in respect to the tower losses. Now, Mala, that brings me to a number of points towards the close of my submissions. A couple of miscellaneous points I ought to pick up and address. First of all, before I deal with limitation, which is our fallback position. Our fallback position on the application is that the negligence claims are statute bar anyway. We are criticised for not filing a defence, and it's suggested that means we have no defence to the 2016.
Sorry, criticised for what?
For not filing a defence, my lord.
Yes.
And it's suggested that that means we have no defence in this action, the 2016 proceedings. That's, my lord, it's plainly not correct to draw any adverse inference from the fact we haven't filed a defence. Under RDC 13.6, the claimant, of course, cannot obtain default judgment if there's an application to strike out outstanding. And if I could just refer your lordship to the notes on which I think is locally referred to as the Green Book, the notes on the RDC at page 180. And I think this page may not be in the authorities bundle, but I'll read it to your lordship and make sure it's inserted. It's under RDC 16.3, filing a defence, and the heading is exceptions to need to file a defence. And it refers to the fact that if an application to strike out has been made, it's not necessary to file and serve a defence. And then it says, indeed, in Hafiz and Damak, where the defendant had made an application under RDC 4.16 and or 24.1, those are applications to strike out. And the court duly ordered that the particulars of claim be struck out. Justice Sir Roger Giles justified his decision against then giving the defendant its costs, in part because the defendant chose to plead, where it could have immediately complained that the points of claim were defective. So effectively, he deprived the defendants of some of their costs of pleading a defence when they didn't have to, because their case was that the action should have been struck out. So there's a related criticism, my lord, made of us to say, well, you asked for extensions of time for your defence and requested particulars. My lord, that's true, but it was all done very expressly on the basis that it was without prejudice to our potential application to strike out for abuse of process. It was done putting the claimants firmly on notice that we were actively considering that application, and it was expressly without prejudice to that. And indeed, a number of the RFIs that we asked for were specifically directed to the question of abuse of process. So cards on the table from us, unlike the claimants in this case. I mean, if your lordship, perhaps I could just show your lordship a couple of those references. They're all in bundle 1. First of all, in the correspondence behind tab 21, that's 223. This is a letter from Clifford Chance at an early-ish stage, 26th of February 2017, where they say at 223 at letter D, reliance is placed on findings of Chief Justice Chadwick in the earlier proceedings, and careful consideration needs to be given to the preclusive effect, if any, of his several lengthy judgments, and the question of whether the proceedings comprise an abuse of the process of the DIFC court. And the application for an extension of time, my lord, was made expressly without prejudice to the right to strike out, and that's at page 258 of this bundle behind tab 23. That's the first witness statement of James Abbott, page 253, paragraph 2. This application, this for more time, is made without prejudice to any applications which it may make to strike out the claim pursuant to RDC 416 and or for immediate judgment. And indeed, both RFIs were served expressly without prejudice to that, which is, and you also will find the first one behind tab 6 of the same bundle, where in the middle of the page, page 64, we said that this request for further information is made pursuant to Part 19. It's made without prejudice to any applications. The second prejudice may be made for immediate judgment and or to strike out. And indeed, some of the requests over the page at 65 are directed to the question of abuse, because you see request 3 is at the first claimant's case that these proceedings could not have been pursued in the 2009 proceedings, and there are consequential requests made, and we asked them, basically, we also asked them if they had any excuse for not meeting the LD guidelines. And similar position with the follow-up request, which appears behind tab 8, served without prejudice and so forth. So the claimants were under no illusions about what was coming, what may be coming. The next point is I referred to forum non-convenience. The reason I raise it is really twofold. In our skeleton, we highlighted the fact that these proceedings were brought in breach of an exclusive jurisdiction clause. And the claimant's skeleton responds saying, no, that's wrong, and in fact suggests we're playing games of some kind. My friend says the jurisdiction agreement has fallen away. They say this in a footnote, because the Deputy Chief Justice found that the investments themselves were concluded in breach of the financial services prohibition, and the consequence, he says, under Article 65, is that any and all agreements between the Khorafis and the banks are unenforceable, including an agreement as to forum. Now, your Lordship may say, why does all that matter? You're here now. The point is this, my Lord, that when these 2016 proceedings were issued, all the indications were that the first defendant, although even already in liquidation at that point, was going to be sued alongside the bank. Now, the first defendant, Bank Sarasin was named in the claim form, and specific relief was identified as being sought against it. That's in bundle 1 at tab 4. That's the claim form in the current proceedings. And at page 14, the Lordship sees a series of reliefs claimed against the first defendant. Now, what has actually happened is that the claimants have sought repeated extensions to the validity of their claim form against the first defendant. But nearly 2 years on, we have no particulars of claim against the first defendant. None have materialized. Now, if these proceedings survive our strikeout application, a question will arise as to whether the first defendant is going to participate. It will arise because the bank, the second defendant, has the benefit of an exclusive jurisdiction clause in favour of the Swiss courts. And the only reason first time round why the claimants were permitted to litigate in breach of that promise in the DIFC was because the Court of Appeal, your Lordship included, ruled that the participation of the first defendants was a strong cause as to why the jurisdiction clause should not be enforced. Just to remind your Lordship, that's in bundle 3 at 46, one finds your Lordship's judgment. And this is this decision in January of 2012 now, where your Lordship's, well, I'll come to the detail, a small part of the detail of that decision in a moment, but just to explain, if the claimants disclose or it becomes clear in these proceedings that, from, for example, the liquidator's information and so on, that there's no realistic prospect of the first defendant participating, on the face of it, in our submission, the bank will have a strong case to stay these proceedings on grounds of forum non-convenience. because Switzerland is in fact where the first claimant agreed to litigate this dispute. I'm not saying an application is inevitable, my lord. That rather depends what happens with the first defendant. Of course, if the proceedings are struck out, none of this will arise. But I ought to flag it up, because I don't want it to be suggested that they're not being open about this. I flag up also the point that in your Lordship's previous decision, the bank has the benefit of the Court of Appeal's finding that it has an effective jurisdiction agreement in place between the second defendants and the claimants that extends to all aspects of their banking relationship, not just claims on the notes. And that's apparent from page 1080 and paragraphs 107 to 108 of the Court of Appeal's judgment. 107 to 108. That's where the court finds that the I won't read it all, but in the last 4 lines of 107, the use of the words all legal relationships between the customer and the bank is a very strong indication that the words the place of jurisdiction for all proceedings is mutually intended to refer to any proceedings in respect of any legal relationship between the customer and the bank. Accordingly, there was in the judgment of the court an effective agreement to confer on the applicable Swiss courts jurisdiction over all the claims advanced by the claimants in these proceedings. And over the page at 1082, paragraph 118, that said the natural forum for the claims against Sarasin Switzerland is certainly Switzerland. So natural forum against us is Switzerland. But that's when the only reason that the claims were allowed to proceed was that the first defendant was being sued. So I'm putting a marker down about this potential application, my lord. And the other thing we may look at is the claim for damages for breach of the forum agreement. But more substantively, my lord, it's our submission that the fact that we're being sued for a second time in breach of an exclusive jurisdiction agreement is a further oppressive feature of this litigation. I mean, suing somebody twice in the same matter is bad enough. Suing them twice in breach of a clear promise to sue them elsewhere, suing them twice in Dubai in a breach of a clear promise to sue them elsewhere, is egregious, and that's what's happening here. And just finally on this point, my lord, as to the suggestion the jurisdiction agreement has fallen away, that's wrong. It's true that Article 65 of the regulatory law provides that where an investment has been missold in breach of the prohibition, it will be unenforceable, but that doesn't vitiate any jurisdiction agreement. The facts of the jurisdiction agreement are all rehearsed in this judgment of the Court of Appeal, and the claimants opened bank accounts, they signed the application forms, including a forum clause, all of that wholly unobjectionable, and the breach of the financial services prohibition doesn't even arguably invalidate that. And in any event, it would be a severable jurisdiction clause anyway. And we may have to have some Swiss law evidence about that. But and we've got a clear Court of Appeal finding that we have a valid jurisdiction clause. Now, well,
I'm not quite sure where we are on jurisdiction. Presumably there's some acknowledgements of service by all grounds around this.
No, there will be an acknowledgement of services. It wouldn't be.
What's it say?
It would have to. I'll have that checked, Ronald.
But anyway, yes. A reservation of jurisdiction.
We didn't reserve jurisdiction, Ronald. It would be a forum convenience form that would be taken, asking the court not to exercise the jurisdiction it does have, because.
Well, it is a jurisdictional issue, but i.e., albeit there may be jurisdiction in principle. But the only basis of the jurisdiction in principle is because, as you put it, the first defendants are parties to the litigation.
Yes.
Yeah.
If you can be quite sure that if we would have been sued,
I'm just trying to find my way to where
Yes.
you are at the moment on the
Yes.
jurisdictional issue. Isn't this a threshold issue?
Well, no, it is an early issue, but an application.
Anyway, all right, let's not waste time. Can you get me a copy of your acknowledgement of service, please?
We will indeed, and we'll add that to the list. Well, the last matter I need to deal with, and I'll be relatively brief on it, is limitation. This is our fallback position in our application, that we say that in any event, the negligence claims are statute barred. Now, the only point taken in the claimant's skeleton on this issue, paragraph 100 and following, is a point in the interpretation of Article 9.2 of the Law of Obligations. And we've been given notice of an Australian authority which suggests that the friend may make some submissions on the facts, but I'll just have to see how that's put and reply to it as necessary. But the only point taken in the skeleton is the interpretation of Article 9.2, which your Lordship will find, if your Lordship can put volume 3 away, and if your Lordship could take that to the authority, our authorities will again tab 30. And your Lordship, at page 545, top of the...
Divided?
30, my Lord, page 545.
Thank you.
At the top of the page, your Lordship will have Article 9 of the Law of Obligations. And heading limitation. And one reference is fraud. It says, notwithstanding Article 38, where a cause of action arises as a result of fraud by the defendant, there's no time limit before which the action must be commenced. 2, for the purposes of an action brought under Chapters 2, 3, or 4 of Part 3, cause of action arises on the earliest date. Those chapters, by the way, would encompass the negligence claims. That's common ground. The cause of action arises on the earliest date at which the claimant knows or ought reasonably to know about the loss that gives rise to the cause of action, provided that any action is brought within 15 years of the date that the cause of action in fact arose. The first article is as I said, references fraud. The second article, 9.2, and the English equivalent, the Limitation Act, we've included in the bundle, the authorities 27. Tab 27.
Yeah.
The Article 9.2 is obviously has a strong connection to the Limitation Act, Section 14A, which your Lordship will find on pages 525, 526 in the bundle, and particularly sub 6 and sub 7 on page 526, which it says this. Well, in fact, I want to refer as well. For purposes of this section, the starting date for reckoning the period of limitation is the earliest date in which the plaintiff or any person with whom the cause of action was vested before him had both the knowledge required for bringing an action for damages in respect of the damage and the right to bring such action. In subject 5, the knowledge required means knowledge of both material facts about the damage and of the other facts relevant to the current action. For the purposes of 6A, the material facts about the damage are such facts about the damage as would lead a reasonable person who had suffered such damage to consider it sufficiently serious to justify his instituting proceedings for damages against the defendant who did not dispute liability and was able to satisfy a judgment. Now, the starting point here, Arnold, is that Article 9.1 deals with fraud claims, as it says, whereas Article 9.2 deals with other claims such as negligence and negligent misrepresentation. That's, of course, an ordinary fair reading of those provisions. They look like they have been modelled on parallel provisions of the English Limitation Act. only argument put forward at the moment to salvage the negligence claims is that Article 9.1, where it refers to fraud, is in fact much broader in its application than you might otherwise think. Rather than being a relatively narrow exception applicable where the claimant can and does plead fraud, that is to say the legal foundation of its case is fraud, it's on the claimant's case a wider provision which comes into play whenever there's a whiff of dishonesty in the background. Now, your Lordship will see from Rafed Skeleton at paragraph 105 that in respect of the equivalent position in England, the fraud provision in England, it's common ground that that only applies where fraud is an element of the cause of action. So to come within the fraud provision, fraud has to be part of your cause of action. Now, and I think the argument being put to your Lordship is, in effect, that having modelled its limitation regime closely on English law, the DIFC has proceeded inexplicably and without commentary to differentiate itself by rendering evergreen any and all claims where dishonesty is only potentially in play, even if it isn't pleaded, or essential part of the cause of action. And there's, of course, nothing to commend that position. Limitations in the area of law where clarity is obviously paramount, and the English authorities certainly are clear that fraud means fraud in this context of limitation, and the claimants point to a difference in wording, because the English statute says based on fraud. Article 9.1 says arising as a result of fraud.
So what's the English provision in relation to fraud?
It's 32, which is back on page tab 27. I don't understand it's not in the extract of the limitation. I apologise.
Okay.
No, we'll put that on the shopping list. I do apologise. But it's common ground that under that provision, fraud means fraud, and fraud has to be an essential element of the cause of action to come within the provision. And it says based on fraud, and Section 32 says based on fraud. We've got a whiteboard here. I could at least read it. But based on fraud and arising out of fraud, this is some angels in the head of a pin type argument. TD is concerned with detail that isn't actually irrelevant. I mean, fraud is based on fraud if it arises from fraud, and vice versa. So, my lord, it is the negligent case plainly comes within 9.2, and no case has so far been made on the facts to say that they didn't know about these the claims more than 6 years before they issued these proceedings. I've found Section 32 in the White Book. Yes, it's 32.1 says, subject to some other provisions, where in the case of any action for which period of limitations prescribed by this Act, either A, the action is based upon the fraud of the defendant, or B, any fact relevant to the plaintiff's right of action has been deliberately concealed from him by the defendant, or the actions for relief from the consequences of the mistake. So it's a mistake. So it's an action based on the fraud of the defendant. We'll have that provision. Yes, and it's quoted in the authority on the matter of the Friends Authorities Bundle. Beeman, it's tab 2 in the Friends Authorities Bundle, which is the decision that makes that point, that it has to be part of the cause of action. If there is a point taken on the facts, if I may, deal with that by way of reply. The other matter Your Lordship raised with me yesterday is costs of this action. Yeah. The best estimate I've been able to get overnight is approximately $825,000, and that I think probably doesn't include all of the costs for this application yet, but approximately $825,000 Your Lordship will know that in this action we've obviously had to review an immense amount of material from the 2009 proceedings, and these double-sided files that we have, 12 of them, are just a fraction of what went on in the 2009 proceedings, and there's obviously had to be extensive review of that, including by lawyers who've never been involved in the case before. And this is one of the problems you get if you're sued twice over the same subject matter. But I think that's probably as far as I can help Your Lordship on that.
Thank you.
For the moment. Unless Your Lordship wishes to
Thank you very much indeed. We'll take a short break if that's all right. Thank you very much.
All right.
You can see it from here. It's in the yes, you can see it. Okay. I'll go this one.
There is some speed, but I'll take it. To